is the philosophical point of the conversation, where we ask ourselves, what should Washington, D.C. be doing? Something very different from what they are doing today. If you could come up with something that they should be working on now, today, that they're not, what would it be?
Well, what I said during the debate on the CISA bill, both 2 years ago as well as last year, still holds true today. The United States needed to get its act in order, and we're moving in that direction. But once we do that, I mean, this is not a domestic issue. Aurora hit it on a topic of being international. I mean, guys in Russia and China and Iran are sitting there today as we're sitting here trying to hack into our government, to our private sector, and law firms and anybody else, and they're doing a darn good job of it.
And law firms are looking to open offices in many of those countries, so you have a bit of a problem there.
And the United States has an obligation to lead in the international arena on cybersecurity. Nobody is better than we are. The NSA can be criticized all day. I happen to think they're an extremely professional group. And I know the caliber of the people that work there, but more importantly, I know how talented the organization is. Nobody is better than we are at defending the cyberspace. And everybody else, all the other major countries know that. They know how good we are. So we have the opportunity, and I think the obligation, to lead in the international arena, to try to find some common space in the world of cyber. Boy, that's going to be a difficult thing to do, but it is up to us to lead.
It sounds difficult to get at the granular level of putting protective measures and procedures in place that should be required of all law firms. I mean, do we see a world someday where law firms or other fiduciaries are required to have chief security officers, or is that just...
I mean, if you're dealing with clients, particularly in any one of the 16 critical sectors, you know, we deal with dozens of data security agreements and policies and procedures and audits and assessments every year, and I think we've all discussed it here. But essentially, they're all requiring a baseline. You know, it's more or less the same but different. And actually, where the government could be helpful in a practical way is to help coordinate so that we are not doing multiple assessments, you know, with clients. That we have some way of maybe assessing, you know, common vendors, assessing, you know, law firms, so that we're all dealing with one standard, and we go through the process once rather than you know churning out hundreds or thousands of man and woman hours trying to respond and trying to address minute variations in each of these standards. I think it's a very maybe a small ball of this, but I think that would be very helpful, and I think that would be very productive and efficient for this economy.
So market forces and communication will move the ball forward. Do you agree with that?
I think there's always going to be a chief security person at a major client, global client, that's going to want more than whatever the standard is, and you've got to sort of assess it well in advance, as I was saying a minute ago, in order to be not only ahead of them, but what clients want now is for us to almost have a better idea of what the risks are in their business in general than they do. That's what they're paying the extra value for. And this is just another of those risks. So if we're not only at the top of our game vis-a-vis our own protective devices, or ahead of where they would require us to be on a simple compliance basis, and similarly are advising them to be in better compliance themselves, we're probably not going to be among the leading firms around, because the issue is so important and top of mind.
Yeah. I mean, it's fascinating to think about the work that you guys do. If we're going to rely on communication and market forces to make sure that, say, every firm in the AmLaw 200 is up to speed on this stuff, I got to say, just as devil's advocate here, I'm a little bit worried about, that one firm that's particularly terrible at this stuff, yet you still kind of have to do business with them. Local counsel. There's so many vulnerable points in the chain. Can you talk to me a little bit about some of where those tension points might be and how they can be addressed?
I mean, I think market forces are important here. I think that you do have certain firms that haven't really stepped up to the plate yet and don't secure their information. But I think all of us in this room, for example, our firms have firewalls, which may help us to avoid that firm breaching those firewalls. I think we also, as we push forward, we have an obligation when we hire local counsel to ask what kind of security they have, cybersecurity they have, and I know that we do it. I know that our lawyers work with our IT people to make sure that whatever information we hand out, whether in the form of due diligence in an acquisition, whether it's a litigation, we work with them to make sure that that information is safe. And without the government intervention, and maybe despite any kind of attempts at government intervention, we've come to the realization that this is an existential problem. And that unless our word, our information, our systems are trustworthy, clients will go to you rather than to me. So we're going to take those steps that mean that the clients feel safe, and that whether we deal with outside counsel, whether we deal with a client, whether we deal with the government, we're going to take the right steps to safeguard that information. I don't think you need the government to help us do it. I think we're very aware of the fact that we have to do it.
Tension points.
It's a very practical and very important question. I mean, there are a lot of different ways that you have to approach it. One is through the technical controls in place. You deal also with the fact that even local counsel is going to be vetted by these largest financial institutions because they deal with hundreds and thousands of law firms. The other thing you have to do is you increasingly need to think about what data you're providing, information you're providing people. Not everybody needs everything. So even within our firm, you don't get access to any. You get access to what you need. So even if someone were to somehow hack my account or get into my system network, they don't get access to everything in the firm. I mean, they'd have to they would have to sort of hack multiple points within the network, and that's really part of the evolving paradigm of cybersecurity. I think that law firms and other companies and institutions are adopting these days.
And further to John's point, there's more discussion now within law firms as to how much data we keep. How long do we keep it? Is there really a necessity to keep it? Law firms forever have kept data probably way, way too long, but that's not the case anymore. And that's what we tell our clients: examine what you're keeping, and do you really need that? And also, how long do you need to keep it? And all of that is under discussion.
That's a pretty fundamental shift in the way business is done. I mean, 10 years ago, businesses held on to everything if they could. Cost of storing it was almost nothing.
Not if they were being well advised 10 years ago. I think 10 years ago, people of prominent law firms, particularly people who are doing litigation counseling, have been telling people to have a different kind of approach to the retention of documentation, of all kinds of documentation. I mean, the issue obviously is that with the technological explosion, the level of the information and your ability to get your arms around exactly how much there is and how far back it goes and where it exists in the cloud and so on and so forth makes it a much tougher, I think, piece of advice to give people, but I think people have been given that advice for a while.
Here's the other thing, is the ability of a law firm to speak as a human to its clients as opposed to a lawyer about their own mistake. So I am a law firm, I have screwed up. And my training and everything I know about myself as a lawyer is to qualify and to be careful and to be